Hello, good morning. Hello, good morning, everybody, and very welcome to our webinar on navigating the competition law landscape. This will be a whistle-stop tour this morning. It's designed really to just whet your appetite for further and perhaps more targeted webinars, perhaps before Christmas and maybe into the new year. Like a shameless YouTuber, if you like the content, if you want to hear more about any specific topic that we'll discuss this morning, well then virtually click the like button. Let us know, send us your comments following this webinar, and we'll hope to address some of those questions through perhaps a more targeted webinar before the end of the year, perhaps, as I said. So look, without further ado, let me introduce the team. I'm joined this morning by my partner, Tara Kelly, and by my senior associates, Liam Halen, Laura Durning, and Grania Morrissey. We're going to talk to really three broad topics. Firstly, merger control. Secondly, competition law compliance and investigations. And then we're going to turn to all things digital and wrap up with that particular topic. So turning first to merger control, and I'm joined by my partner, Tara Kelly. Tara joined us a couple of years ago from Simpson Thacher in London and New York. So I think it's fair to say there's very few things on the merger control side, either nationally or internationally, that Tara hasn't seen. So let's perhaps, Tara, just focus a little bit first on timing. It's the first question that instructing counsel often ask us. Particularly foreign counsel. So talk to us a little bit about timing. How long will folk find themselves with the Irish regulator once they notify a notifiable transaction?
Sure, thanks, Niall. We've actually seen an increase in the average length of the review period this year, unfortunately. Looking at unconditional phase one clearances so far in 2020, the average review period is up around 39 working days. Which is a fairly significant increase on last year, which was 28 working days, and on the year before when it was 24 working days. And it seems the key driver here is that the CCPC is increasingly relying on formal requirements for information. And the effect of an RFI is essentially that it stops the clock on the 30 working day statutory review period, and it restarts the clock on day one, on the date that the parties actually respond in full to that RFI. And we've seen the CCPC issue formal RFIs in roughly a quarter of all transactions cleared so far this year. So they're definitely relying on it more heavily than they used to. We are hopeful that the recent introduction of the simplified procedure, which came into effect in July of this year, will go some way in shortening the review period for straightforward transactions, notwithstanding the fact that the statutory review period actually remains unchanged for the simplified procedure. It's early days yet to really tell how effective the simplified procedure will be in doing that, but initial indications certainly suggest that for straightforward transactions that are suitable for the simplified procedure, you could be looking at a short 15 working day review period. But there is a little bit of uncertainty around the level of uptake for the simplified procedure. A number of exceptions have been carved out, and the CCPC can require parties to revert to the standard form, which could cause delays, and has already happened in one instance this year. And so it does remain to be seen exactly how effective it will be in achieving that goal of shortening the review period. I think the takeaway for clients here today is essentially, if you're in a standard form world and you don't get a formal RFI, then you're looking at roughly a 24 to 30 working day review period. If you get a formal RFI, your review period is going to be longer than 30 working days. And really the length will depend on how many questions you get and the complexity of those questions. If you're in a phase two world, our recent experience tells us that the review period can be extremely protracted, potentially in excess of 200 working days. But thankfully that tends to be the exception rather than the norm. And then the light at the end of the tunnel is potentially the simplified procedure, where for straightforward transactions, you might escape after roughly 15 working days.
Okay. Look, I suppose what our clients often ask us as well, Tara, particularly when we're notifying transactions and working with counsel outside Ireland in notifying those transactions outside Ireland, we ask about trends, developments in those jurisdictions that we tend to notify transactions in. If I were to ask you about the trends and developments that you're seeing in the Irish merger control landscape, what would be your thoughts on that?
I think one of the most obvious trends we're seeing in recent times is that the CCPC is taking a more interventionist approach to merger control. And so we see this, for example, in the CCPC increasingly seeking commitments from parties as a condition to clearance. And so over the last couple of years, anywhere between 6 and 8% of all transactions cleared have actually involved commitments from the parties. And what's interesting about these cases is that they're not all cases of horizontal competition concerns. There's been a few cases where commitments have been offered and where the predominant theory of harm was actually vertical. So in other words, where the parties are not even competitors, but actually operate at different levels of the supply chain. I think it's also worth noting that a lot of the commitments offered by parties in recent times have some sort of behavioural element. And competition regulators like the European Commission and the FTC and the DOJ in the US have traditionally favoured structural remedies like a divestiture. But we see the CCPC here rely quite heavily on behavioural remedies, whether on their own or in combination with structural commitments. So that's definitely something to bear in mind. And this interventionist trend is consistent with what we're seeing elsewhere, certainly at the European Commission level and in the UK as well. And I think the takeaway for clients here is that if you do have a transaction that raises real substantive issues, I think it's a good idea to be prepared for the possibility of commitments, but to bear in mind that they don't always have to be structural, that it is often possible to negotiate a behavioural remedy, which can be a lot less onerous or more palatable than a structural commitment.
Okay, thanks, Tara. I suppose, when we look back at our advices over the years, there tends to be stock questions that we get asked by both Irish clients and clients outside Ireland on the Irish merger control landscape. And I suppose that you can pick themes out of that. There tends to be quite a few misconceptions about how our regime operates. If you were to perhaps in a virtual bullet format, let me know about what those common misconceptions are from your experience.
Sure, there's a couple of misconceptions that we see quite regularly. I think the first is probably clients who assume that if they're acquiring a minority stake in a business, that they don't need to worry about merger control. Actually, a change of control can be brought about in a number of different ways, including, for example, by acquiring vetoes over important strategic business decisions. So if, for example, you're acquiring a small 15% equity stake in a business, but you were also going to obtain, vetoes over a budget or a business plan, and then, this is very likely going to give rise to a change of control. And if you meet the turnover threshold, then a mandatory notification would actually be required in that instance. I think another example is probably the acquisition of assets. Sometimes clients think that if they're just acquiring an asset or a bundle of assets and they're not acquiring a company, that they don't need to worry about merger control. But actually the merger control regime applies to acquisitions of assets that constitute a business to which turnover can be attributed. And so that is a case-by-case assessment that needs to be done and is something to bear in mind for clients. Another kind of top misconception that we see is, that no merger control filing could possibly be required if the target has no turnover in Ireland and has no presence in Ireland. Well, oftentimes that is true, but actually in the context of an acquisition of joint control, where you have more than one purchaser acquiring control of the target, that the turnover threshold can actually be met by the purchasers alone, regardless of the fact of whether the target has Irish turnover or any connection with Ireland. And then on the purchaser side, we sometimes see clients say that the purchaser doesn't meet the turnover threshold because It's, for instance, an SPV that's been incorporated specifically for the purposes of the transaction. So it doesn't have turnover, and how could it possibly therefore meet the turnover thresholds? But actually the turnover thresholds are calculated by reference to the purchaser group. So you actually look at the ultimate parent of the acquiring entity and everything that is controlled by that ultimate parent, including the SPV, but also everything else. And so oftentimes the turnover thresholds are met by the purchaser, even where the actual acquiring entity doesn't have any turnover. And then last but not least, less frequently, clients thinking essentially that if they acquire their closest competitor in the market and the parties don't meet the turnover thresholds, that they don't need to worry about competition law and merger control. What's very helpful to bear in mind here is that there is a voluntary merger notification regime in Ireland, which can be very helpful in this sort of scenario, for certainty, because essentially, while it might be true that a mandatory notification is not technically required, it would be open to the CCPC if they had concerns about a transaction and to try to intervene in the deal. And it can go to court and seek an injunction and various other remedies to try and to prevent the transaction going ahead. If that is a realistic possibility, or if there's any concern, and it does depend on the client. Some clients are more risk averse than others, but the voluntary merger notification regime is very useful in that regard. And we did one very successfully for a client last year, and it was a relatively short, straightforward notification, and then you just get that certainty of having your merger clearance decision.
Yeah, look, I think that's really important. As we know, voluntary notifications in Ireland are particularly rare. But I think one of our takeaways from the recent voluntary notification that we made, and the observation I would have, was that how smooth the process actually was, how very pragmatic the Commission was in dealing with it, how helpful they were in bringing us through the process as well. And I know the client experience out of that was positive as well. So I think kudos to our regulator in that regard. Tara, we're going to release you now for a little while. I know you're going to come back to us again towards the end to talk about one of your pet projects. That's the overlap of competition law and data protection law. So with that in mind, I'm going to move on to competition law compliance and investigations. And first of all, on the compliance front, I'm joined by my senior associate, Liam Halen. And Liam is going to bring us through some of the key issues that we see from a compliance perspective. I should say as well that we're very happy to take questions as we work through this. We might save them until the end, but do feel free to drop us a note through the chat function if you want to pose any particular question, and we'll try to answer as many as we can. So Liam, over to you. Let's start with a more general question. From a compliance perspective, what can companies do at the moment to avoid, I suppose, inadvertently falling foul of the competition rules? How do they keep their shop in order in headline terms?
Thanks, Niall. Well, I suppose the first thing a company can do is to put in place an effective compliance strategy or program to minimize any risk of breach of competition law. The consequences of a breach can be very serious and costly for a business. Can include up to criminal sanctions for the most serious offences, substantial fines of up to 10% turnover, lengthy investigations, or even potentially third-party damages claims. So an effective compliance program can raise awareness throughout a business. So what might that entail? A compliance manual being central to most programs, but depending on the company, it might be advisable to also include document and management retention guidelines or dawn raid guidelines, contact reporting. So a compliance program is not necessarily a one size fits all, and it'll depend on the business and the market they're operating in. So we would typically assist clients putting that program in place and designing it to suit that company's needs. So it doesn't need to be a costly exercise, but it can be implemented it should be implemented fully and regularly updated. So I suppose once that compliance program has been developed, it will need to be communicated throughout the company through education and training, perhaps even in a post-COVID world, mock done rate exercises. So I think compliance is not something that should be left to the legal department. Unfortunately, conduct by individual staff members can result in a breach. So the sales team, marketing, staff involved in distribution or licensing arrangements, anyone who might be attending a trade association meeting are examples of the people that should be required to take the training.
Okay, Liam, look, I suppose companies tend to sometimes draw attention towards their activities, unintentionally, inadvertently. Sometimes it's entirely appropriate, by the way, but sometimes it's not, or at least requires a degree of explanation. What can those companies do to avoid that scrutiny?
Yeah, sure. Well, one area where we regularly see how companies might inadvertently draw attention from the authorities is relating to internal documents. There's an increasing reliance on competition authorities in the EU, in the UK, in Ireland, on internal documentation being the smoking gun or the hot document. They're seen as valuable evidence of a way in which a company views a range of issues in the market that they're operating in, who their competitors are, and irrespective of whether it's possible to test the reliability of some of those statements, they can be used as evidence. So we've seen cases where the first look at a company's internal thinking can disproportionately color the view of a company's conduct, and it can be difficult to later challenge the accuracy of those statements. And it mightn't necessarily be internal documents. It could be published annual reports, can prove embarrassing down the line, if there's exaggerated claims of market share or dominance, for example.
Yeah, look, and I suppose if we track back through history, let's look at the Microsoft Windows Media Player refusal to license interface information cases. Look at some of the statements from Microsoft in that case that were terribly unhelpful. You can perhaps argue on the law at times, but sometimes when there's rather blunt statements that they're very hard to get away from, and they go to intent. Sometimes we saw that as well in, I suppose, the OFT's price fixing cases, some of the hub and spoke cases, and we saw it in I suppose replica kit and cases of the like. So I suppose moving away from hot documents and internal documents, dealing with customers, dealing with suppliers is a fact of life for all companies. From a compliance perspective, give us some headlines, Liam, in terms of what companies should look out for when they're dealing with customers and suppliers, etc.
Yeah, thanks, Niall. Well, one of the general principal requirements under competition laws is that companies act independently of each other, and information exchange can result in a potential breach where that information happens to be competitively sensitive. It removes uncertainty as to future conduct, or goes so far as to facilitate collusion. So the different types of characteristics of what might constitute competitively sensitive information include information that's not in the public domain, that's considered strategic or commercially sensitive. So typically any element of price, the actual price, rebates, discounts is the most sensitive, but also information relating to costs, capacity, production levels can be considered strategic from the authority's perspective. And so the more individualized nature of the information, how frequent are exchanges, is the information recent or historic, all weigh into the consideration of whether information is competitively sensitive. And as you alluded to earlier, information exchange can also happen inadvertently through an intermediary or a third party, a common customer or supplier, as we refer to as hub and spoke or ABC information exchange. While there mightn't be a huge amount of case law in Ireland on this subject, we've seen the UK has had a number of cases in this area, such as replica football kits or Hasbro Argos or a couple of others. And here the retailers were found to indirectly exchange pricing information through their manufacturers. So I think one of the key takeaways is that one meeting or one exchange of sensitive information may give rise to a potential breach. So this is where your compliance program and your training can come in handy. And, you know, while no compliance program can prevent every breach, you know, having it there, raising that awareness can go some way to alleviating those risks.
Yeah, thanks, Liam. Look, I asked Tara about trends, so it would be remiss of me not to ask you about trends. I suppose just like the interface between privacy and competition law is somewhat sexy at the moment, well, you know, in our little world, ECN plus is in a similar bucket at the moment. Can you talk to us a little bit about the trends that you see at the moment, Liam?
Yeah, sure. Thanks. Yeah, that's obviously the biggest development or trend from a compliance perspective is the ECN plus directive. And so this is designed to empower the national competition authorities across different member states to make them more effective enforcers. You know, as has been alluded to already, an increasing trend across the EU, UK, the US is greater enforcement and intervention from the authorities. And that's a trend we'll likely see in other jurisdictions following the introduction of this legislation. So some of the main provisions that are going to come with this will increase the enforcement powers for the competition authorities in Ireland. We're likely to see increased additional search powers to gather relevant evidence to search mobile phones, laptops. The CCPC will you know, potentially get the first opportunity to impose administrative fines in non-criminal proceedings, or you know, imposing behavioural or structural remedies for particular enforcement proceedings. So we'll also potentially see for the first time a leniency programme in cartel proceedings in Ireland. So the date that the directive is due to be transposed into laws is next February, but up until now there's been very little consultation and debate on the implementation of that directive. So I suppose question whether, given the current circumstances, the member states might be given some more time to bring that into effect, but that's I suppose a wait and see.
Thanks, Liam. And look, we could speak about compliance for a long time, and certainly there could be a webinar dedicated to compliance all on its own. Perhaps there may be, depending on demand, I suppose, into the future. Liam, I'm going to turn to Laura now. Laura Durning is a senior associate in our team. Laura's been heavily involved in a number of the recent investigations by the CCPC, most notably the ticketing investigation and the private motor insurance investigation. Laura is also advising Aveco in relation to the follow-on action for damages arising out of the trucks decision from Europe and that rather significant 2.8 odd billion fine. So Laura is appropriately positioned to talk about investigations and related issues. So Laura, I think we've been seeing increased enforcement over the last number of years by the Commission. It certainly kept us busy. Can you talk to us a little bit about, you know, what companies can expect when an investigation is launched in this jurisdiction?
Yeah, sure. And that's right. Absolutely. In terms of kind of how it might land on them initially, it's effectively where the CCPC becomes aware of a suspected breach of competition law. So they may become aware through kind of a number of different avenues. Internally on their own initiative, they will continuously conduct, as you know, market surveillance type activities on a continuous basis, or they may receive the information externally from, for example, a complaint or a number of complaints that they receive. So if they do decide to ultimately open an investigation, in terms of what they can expect, even just kind of looking at the outset of an investigation, the CCPC will typically issue the business with a request for information, and they will issue them with a witness summons. So the witness summons is really the chunkier of those two. And even within it, you can kind of break it down into two parts, I would say. One is a request for documentation, and the other then is a requirement for the addressee of the summons, which is usually the MD or the CEO of the company, to appear before the CCPC for witness summons hearings to provide evidence under oath. So they're actually required to swear an oath, and then the CCPC case team will put a number of questions to them that they'll be required to respond to. So it's kind of akin in many respects to actually providing evidence in court. And that individual can remain under oath for the duration of the investigation, which can span a number of years. And failure to comply with the witness summons is a criminal offence. So it's definitely not something the clients take lightly. So it is a serious scenario. So that, in kind of very headline terms, is what a business might expect in the early stages of an investigation.
Yeah, and I think it would be inappropriate to kind of underestimate how burdensome some of those requests for information actually are, almost like a merger proceeding. It always makes sense in those cases to have a discussion with the regulator to see whether those type of requests can be appropriately narrowed down in such a way that both the subject of the investigation and the regulator is happy that what is being asked for is required, and what is being asked for actually satisfies the regulator. So I know that's something that takes up quite a lot of our time when we do get a witness summons or an RFI, whether it be in an investigation context or in a merger control process. Again, sticking with the theme throughout today, we talk about trends. Talk to us a little bit about trends on the investigation side of things, Laura.
Sure, yeah. I think the kind of overarching trend that we're seeing is that investigations are becoming increasingly demanding. So kind of a number of things, I guess, flow from that. I think in part it's due to these wider document requests. And we see this in the context of both investigations and a number of merger control cases that we're involved in as well. As Liam said, there's definitely an increased reliance by competition regulators, not just in Ireland, but on internal documents. So a lot of their requests are kind of designed to capture these internal documents. In many respects, they're quite similar to a discovery request in the context of proceedings. So you could potentially be dealing with millions of documents. So kind of with that, I guess a trend that is coming with it, and certainly something that we've been experiencing over the last number of years, is an increased requirement for forensic assistance. So as you know, if we receive, or a client receives, a really large document request, we'll often engage an IT forensics company, and that company, as a lot of people will be aware, they'll effectively be able to go into the business's systems. So once we figured out where the potentially responsive material sits and who holds it, the forensic company can go in and they can extract that data, and they can effectively port it over to an online platform. And from that, then you can run a number of searches just to try and move things along more efficiently. You can limit the data to the particular time period that the CCPC is concerned with. So thankfully, whilst the investigations are definitely becoming more demanding, systems and processes are adapting with that, which is helpful, obviously. Another trend, I guess, that we're seeing is the increased use of economists, both by the CCPC and also then by the parties. So we would work regularly with economists. So not a huge change there, but we're definitely seeing things going in that direction a little bit more. And then I guess the last thing I would finish with, not quite a trend, but it kind of falls from everything I've just spoke about, is that investigations are naturally becoming lengthier. So they can often involve a number of different parties, which results in, potentially the CCPC having to gather and assess millions of documents. They will conduct these witness summons hearings, and one party alone may have to attend 4, 5, 6, 7, 8 witness summons hearings. So if you multiply that by a number of parties, it can clearly all add up, and your investigations can take a long time. So just thinking kind of through our own experiences, we're advising clients, as you said, in the context of the ticketing investigation. That's actually coming up on 4 years. It'll be 4 years in January. and the CCPC's investigation into the private motor insurance sector has been running for just over 4 years. So that'll kind of give you a bit of a flavour in terms of the duration of some of the current investigations at the moment.
Yeah, Laura, look, I think that puts it into perspective. I said it was a whistle-stop tour, but let's make it as practical as we possibly can on the investigation side. Let's have some recommendations from you in terms of how these processes might be managed if companies find themselves amidst an investigation.
Sure, yeah. And I will do it in a whistle-stop form, or else we could be here all day. But just kind of following on, I guess, from what I've said, I think it's really the main message from us and for me is to be conscious of and recognize that investigations are demanding and they require commitment. And that also involves kind of, internal resourcing commitments as well, which we appreciate can be difficult. So investigations, as I say, can last for a number of years. So particularly with that in mind, the initial steps are really important. You want to get it right from the outset. So get all of your teams involved. Internal, external, tease out the various requests. If you're dealing with a document request, for example, figure out where the likely data sits, which employees in the company are likely to hold it. If, for example, you have a document destruction policy, put that on hold, certainly at the beginning. There's lots of things that you can be doing in the early days, and ultimately that will save you time and resources and costs in the long run. And then the only other tip that I think I would mention is just to lean on what Liam has said, is that before you potentially even find yourself the subject of an investigation, there are a number of different things that you can do from a compliance perspective.
Laura, that's really helpful, and thank you for that. We're going to release you now, so thank you for taking us through investigations this morning. We're going to pivot a little bit now, and we're going to turn to all things digital. It's a little bit of a sweet spot for Mason Hayes, if I can say that. It's something which we pride ourselves on. We're lucky enough to advise some of the big tech companies in Ireland and elsewhere. And we're lucky enough to have folk in our number who have, I suppose, experienced this on both sides. Grania Morrissey joined us not so long ago. She decided to move back from the UK. I suppose after 7 years at Ofcom, I think we could call Grania a gamekeeper turned poacher of some sort. I think you've seen it from both sides. But let's perhaps not talk anymore about that, Grania, and let's turn to some proposals out of Europe that deal with, I suppose, the introduction of ex-ante regulation for online platforms. We've got a regulation out there. Just tell us a little bit about what it looks like from your perspective.
Thanks, Niall. So yeah, in June of this year, the European Commission launched public consultations on proposals for a Digital Services Act and a new competition tool, both of which include proposals for ex-ante regulation. By ex-ante regulation, we mean regulation which is imposed prospectively to regulate future conduct, as opposed to ex-post regulation, which is imposed retrospectively to address conduct that has already occurred, and this is what we're more familiar with. Taking the Digital Services Act first, this will modernise the legal framework for digital services, which is currently contained in the e-commerce directive from 2000. The European Commission is concerned at the level of control exerted by large online platforms who leverage their advantages, such as, for example, access to huge amounts of data from one area of their activity to improve or develop services in adjacent markets. The Commission is also concerned that a small number of large online platforms increasingly determine the parameters for future innovation, consumer choice, and competition. The overall goal of the initiative is to ensure that markets remain fair and contestable, and also to provide improved regulatory oversight with the power to take action where action is needed. The European Commission aims to achieve its goal by means of two main pillars. The first pillar is a new set of rules which would frame the roles and responsibilities of all digital services to address the risks faced by their users and to protect the rights of their users. The second pillar, which is of more relevance to your question, is the ex-ante rules, which will cover large online platforms who act as so-called gatekeepers. And the aim of the Exante rules is to enhance competition so that consumers have more choice and that newcomers have better opportunities to enter the markets and compete. The framework will complement the recent platform to business regulation. And the options being considered by the Commission are a kind of blacklist of so-called kind of prohibited practices. This would include, for example, certain forms of self-preferencing, exclusive use of data. They're also proposing an option for tailor-made remedies, which would address specific issues. The types of remedies could include, for example, non-personal data access obligations, data portability, and interoperability requirements. The other consultation that the Commission issued relates to a new competition tool, which would address structural competition problems, which have been identified by the European Commission and which they consider cannot be tackled under the existing EU competition rules. Again, here they're concerned with monopolization strategies by non-dominant companies with market power and parallel leveraging strategies by these dominant companies into multiple adjacent markets. The overall purpose of the new competition tool would be to prevent fast-moving digital markets from tipping too far towards a dominant firm. Using this new competition tool, the European Commission could impose behavioural or structural remedies. So this could include divestments, breakup, and other kind of line of business type restrictions without having to find an infringement of competition law. This is worth noting, as because there would be no need to find an infringement of competition law, it would mean there would not be a fine or the possibility of follow-on damages actions. There are 4 different policy options currently being explored: 2 dominance-based competition tools, one of which would be limited in scope to certain digital or digitally enabled markets, and also 2 market structure-based competition tools, again, one of which is limited in scope to certain digital or digitally enabled markets. It is the European Commission who would exercise these powers rather than the national competition authorities. It's also worth noting that in its consultations, the European Commission has been keen to stress the complementary nature of the proposals for the Digital Services Act and the new competition tool, and that it was kind of consulting, at least at the outset, together so as to ensure consistency and avoid possible overlaps. The European Commission's proposals are expected to be published by the end of this year, and there are reports that the Digital Services Act will in fact be published on the 2nd of December.
Okay, Grania, it's always, I think, helpful, and we certainly do this to kind of look across the pond to see what type of developments are emerging over there. And the CMA, the Competition and Markets Authority in the UK is always a good place for us to look. I know that they've been particularly active in this space at the moment. They're talking about introducing a regulation to govern the conduct of online platforms. What does that look like? Is it, I suppose, unlike perhaps other developments that are happening at the moment, is it in line with the EU thinking, or is there a degree of divergence in play there?
Thanks, Niall. Yeah, I think overall the CMA's proposals are probably broadly in line with those proposed by the European Commission. The CMA's proposals, which were set out in its July report on its market study on online platforms and digital advertising, builds on proposals in the 2019 Furman review, and calls on the UK government to introduce a new pro-competition regime which would tackle the online giants' market power. The regulatory regime for the online platforms will be enforced by a digital markets unit, which it considers should be able to develop kind of principles-based codes of conduct which would govern the behaviour of firms with what it terms strategic market status. This is a new regulatory standard, and it will cover those who have enduring market power over strategic bottleneck markets. It's something less than dominance, and it's obviously something that will have to be developed as the proposals go on, as it's an entirely new standard. The code will be based on high-level principle based of fair trading, open choices, trust and transparency. And each platform designated as having this strategic market status would have its own tailored code. The Digital Markets Unit would also have a power to make pro-competitive interventions to tackle the sources of market power and increase competition. This could include data-related remedies, for example, third-party access to data, interoperability and portability requirements, data separation interventions. An example given is that Google could be ordered to open up its click and query database to rival search engines. Potential rivals would then be able to use this data to improve their own algorithms and compete, therefore helping to overcome Google's scale advantages in data. Other interventions could include ones aimed at increasing consumer choice and control over the use of their data. Again, using Google as an example, Google could be restricted in its ability to secure its place as a default search engine on mobile devices, so as to allow more choice for customers. More drastic interventions are also considered, which could include separation measures. These could range from operational separation to full ownership separation. The Digital Markets Unit would also have power to enforce the codes of conduct. These powers of enforcement could include suspension, blocking or reversing decisions by platforms, and there would also be financial penalties for non-compliance. In terms of next steps, a digital markets task force, which was commissioned by the UK government, but is spearheaded by the CMA with input from Ofcom, the communications regulator, and the Information Commissioner's Office, so the data protection regulator, are tasked at advising the government on how this new regime should be designed and must report by the end of this year. It's also worth noting that recently Andrea Cocelli, who's the CEO of the CMA, was reported as saying that he was preparing to mount investigations into Google and Facebook if the UK government did not act fast enough to curb their powers. This follows on from the CMA's report, which I mentioned earlier, and he's given the UK government a year to come up with regulatory proposals for the regime for big tech. So I think it's very much a question of watch this space.
Ron, you're really helpful. I think, you know, when the word ex ante regulation is used, I think the immediate reaction of clients, not in small number, is one of perhaps shock horror, and there are various levels on the spectrum of that shock horror. Is it something that clients should be really concerned about? Look, we've seen ex ante regulation in a number of other areas, and you know, your area of telecoms in particular. Is it something we should be worried about, or is it one of those nothing new to see here type answers?
Thanks, Niall. Yeah, I think it's very much something that it's, as you say, it's nothing new. It's been around in the telecoms sphere for, you know, over 20 years. So there's plenty of experience in what does and doesn't work in terms of ex ante regulation that the Commission will be able to access in developing its proposals in this area. It can be a very useful way in kind of allowing time to consider how markets actually work and kind of take the measures so that you're actually intervening in the market so as to ensure that competition will either be introduced or will be encouraged and developed over time in that market. As we said, it's an absolutely integral part of the telecoms regime, which actually, when you're opening a market review in this regime, the first question you ask yourself is simply, is the market that I'm looking at, is this effectively competitive? Under the telecoms regime, there are certain markets where there's a presumption that they're not competitive. And for others, if you want to answer this question, there's a kind of set of criteria that you must consider, which is known as the 3 criteria test. And using those questions, you consider whether the market is actually susceptible to ex ante regulation. The test looks at barriers to entry, market structure on a forward-looking basis, and also whether competition alone is sufficient to actually address the identified market failures. It is not clear, I think, yet from the kind of very early stages of the EU proposals whether such an approach is considered here, but it would seem very sensible to at least have some sort of set of objective criteria that must be considered in deciding whether the European Commission should exercise its powers. And I think another point to consider is whether these new tools will be seen as to be exercised as alternative to the kind of existing ex post competition law powers, or as in the case of telecoms, only to be exercised where the competition law powers are not sufficient to address the problems identified. So I think that's very much a point to kind of watch out for as these proposals develop. It's also worth noting that in telecoms, it's a forward-looking analysis that is carried out. Again, this could be more challenging in the context of digital markets, which, as we know, are kind of dynamic, fast-moving. Market power can grow substantially in a very short period of time, but could also be eroded relatively quickly. I think this contrasts with telecoms, which, although there's been developments over time, it didn't kind of change quite as quickly. So I think this is just an area that in developing these proposals, it should be considered how much the learnings from telecoms can be carried across and just what the kind of issues can be in looking at something on a forward-looking basis. I think one other point to look at is under telecoms, which is once you decide that a market is not effectively competitive, the regulatory authority must identify the undertakings whether they have significant market power, which is a position equivalent to dominance in a defined market. So this is a higher threshold than the UK's proposed strategic market status threshold, which is something less than dominance. It's not overall yet clear what type of standard the EU will go for, although we do note that some of the proposals are dominance based. So again, there may very well be some more to learn from the telecoms regime in developing a standard in this regard. I think one other point that I would note is that ex-ante powers are not a quick fix. I think this is one of the key concerns that the Commission has stated in relation to its experience with using its existing competition law powers, that it can be quite slow and takes time to intervene. But I think the experience from telecoms regulation shows that, you know, ex-ante powers can also take time, especially as markets become more complex and there is more information to consider. And there can also be a high risk of litigation where parties are not happy with the proposed ex-ante regulation. So it's very much something that's not necessarily the quick fix, I think, that the European Commission might have in mind. So I'd say, just to sum up, overall, I think there are some very useful learnings and important experience that the European Commission can gain from the experience in telecoms. It's really important that the Commission engages with the national telecoms authorities on their experience of how ex-ante regimes worked in practice, so that they understand both the benefits and the pitfalls. And it's notable that in the UK, it's clearly adopting this approach because, as I mentioned earlier, the Digital Markets Task Force is also made up of Ofcoms, so the National Communications Regulator, who are clearly able to give some advice as to how of their experience of ex-ante regulation.
Yeah, Grania, thank you very much for that. You know, the time with the regulator was clearly well spent and ultimately to our benefit. So thank you very much for that.
Thank you.
I said that I would welcome Tara back in before the end of our webinar. So I'll ask Tara to rejoin again. Just to our attendees, keep the questions coming. There's a very large number of them there at the moment. We'll get through as many of them as we can before we close up just shortly before 12 o'clock. But before we do that, Tara, looking back over time, I remember when we were looking in the past, when certainly I was a little younger, about the refusal to license interface information type of cases where we saw copyright and intellectual property law tread unexpectedly perhaps into the realm of competition law, and folk talked about tension. You know, they talk about tension today between competition law and human rights law, and there'll always be that tension. I suppose at the moment it's no more evident than in the realm of data protection or privacy and competition law. Are we seeing a blurring of the lines between competition law and privacy law at the moment, do you think?
Thanks, Niall. Yeah, I think the intersection between data protection law and competition law is something that we're increasingly seeing in our work. And as you mentioned earlier, it's a particular area of expertise and interest for us. I think, you know, you could dedicate an entire webinar to this topic, and we only have a couple of minutes. And so just in very high level terms, I think historically the European Commission, while it's been mindful of issues posed by data concentration, it has generally been quite careful to contain its analysis to the competition law implications of data accumulation and use. But that is definitely changing, and we're seeing an increased focus on the intersection between protecting consumers and their data on the one hand, and promoting competition and market structure, fair market structure on the other hand. I think if you look at the CMA proposals, and in particular, which Brian helpfully ran us through a few moments ago, you can see some examples of this change in focus. Taking the proposed code of conduct, for example, that's proposed to be built on 3 pillars or principles, one of which is trust and transparency. If you look at the proposed interventions, some of those are designed explicitly to increase and enhance consumer control and choice over the use of data, and in particular the fairness by design obligation on platforms to maximize users' ability to make informed choices over how their data is used. And looking at the European Commission proposals, the examples are a little bit less explicit, but just taking, for instance, data-related interventions like data portability and data interoperability, while they may be designed to reduce barriers to entry and expansion, they do also have the sort of dual effect of facilitating consumer choice and control over data as well. And so this shift in focus on the intersection between data protection and competition has largely been driven at the national level. And I'm sure everyone on this webinar will be familiar with the German Bundeskartellamt's abuse of dominance case against Facebook. And I think that's a very good example of the agenda being driven at a national level. And there, the Bundeskartellamt essentially in very high level terms alleged that Facebook's data collection practices breached the GDPR and therefore were an abuse of dominance under German competition law. And that wouldn't be a very obvious theory of harm under EU competition law. One sort of left scratching their head as to where the competitive harm is. But interestingly, Germany's highest court recently ruled that issues of data processing, data accumulation and data exploitation are all issues that should be considered under EU competition law. And the problem with this convergence is the potential for uncertainty and confusion. Data protection laws and competition laws have very different aims. So an overlap between the 2 regimes obviously creates the potential for inconsistent enforcement. And anyone familiar with the GDPR will be aware that it imposes fairly onerous transparency requirements on data controllers, and also introduces that data protection by design duty. So it will be interesting to see, for example, how the CMA's trust and transparency proposals and fairness by design duty will square with these very similar already existing concepts under the GDPR.
Yeah, thanks, Tara. We talked about trends. We talked about developments under the various other headings. So let's conclude your section with takeaways. Talk to us about a couple of takeaways as this new regulation comes down the tracks.
Yeah, I think first and foremost, what's important for everyone to bear in mind is, traditional competition law rules still apply. So it's important not to lose sight of those. I think, even in the digital world, I think, the biggest wars between tech giants will continue to be fought on the basis of traditional competition law principles. So they're certainly no less relevant, but, may be complemented obviously by this additional new regulation. I think secondly, on the merger control front, data is clearly in the spotlight. So if you are a party to a transaction where there'll be data aggregation between 2 previously independent undertakings, I think you should expect that you'll get more questions and potentially have a longer review period, and in particular if you're before the European Commission. And then more generally speaking, if you do collect large volumes of user data, or if you leverage user data from one market for the purposes of entering into or expanding into another market, I think you should anticipate that your conduct could be more closely scrutinized by competition regulators, in particular if you're dominant or if you might be alleged by your competitors to be dominant.
Great, and thank you, Tara. I see we're coming up to 11:57 at least on my clock at the moment. We've got a lot of questions. Let's just try to get through as many of them as we possibly can. We promised our marketing and events team that we would conclude by 12, and we will deliver on that promise. So they'll allow us to conduct more of these perhaps into the future. Tara, whilst I have you, question in relation to managing a multi-jurisdictional filing under the merger control rules. We've had a number of these. Our clients tend to trigger notifications in a number of different jurisdictions. Give us some headlines, Tara. What are your steps when it becomes clear that, well, first of all, you got to look at the turnover, see where it's allocated, but like take us from that point and talk to us a little bit about timing, trying to make sure everything fits together as best you can.
Sure. So I think once it's established that you have a merger notification in a number of different jurisdictions, step one is obviously to retain local counsel that you trust and are familiar with, and we would have a list of local counsel throughout a large number of jurisdictions throughout the world that we would work with on a regular basis, and then, as you say, Niall, figuring out timing is definitely one of the first things you need to do. Some jurisdictions are renowned for having extremely protracted review periods. Certainly when I started doing multi-jurisdictional analysis many years ago in London, China had the reputation for being the longest straw, unfortunately. I think that moved on afterwards to Mexico, and I think the UK now might even be a contender for the jurisdiction where you really don't want to have a merger filing. And so this does change over time, so it's important to stay abreast of developments in each jurisdiction and know which notification is likely to be the long pole, and make sure that gets the attention it deserves, and get your notification in nice and early. And I think another point that's very important to bear in mind is that a lot of these regulators all over the world do actually communicate with each other. And so it's important to make sure that your notifications in these various jurisdictions are consistent. You're not saying X in one jurisdiction and Y in another, and that can often come back to haunt you. So that's another thing that's important to bear in mind.
That's well done, Tara, in less than a minute and a half. Again, number of questions here. I'll ask the team to respond as quickly as we can. Happy to take any of these offline as well, folks. So if you want to drop us a line on some of these. Grania, to you actually, you spoke about the new proposed competition tool. Will it require a treaty amendment? Query from Peter.
We don't think so. I think the European Commission, in its impact assessment, I think referred to its legal basis as being Articles 103 and 114 of the TFEU. But I guess time will depend on once the proposals are further developed. But at this stage, we don't think so.
Yeah, I think that's right. A question from our friend Colm O'Grady, and congratulations from us all, Colm, on your new arrival. You've asked about dawn raids. What do they look like in a post-COVID world? Your guess is as good as mine. You ask also whether we'll see more visits to homes, given, I suppose, a move towards remote working. Entirely possible. As you know, in your previous life as a competition specialist, the CCPC at least may search, any place where business is carried on, and that can be the home, that can be cars, trucks, lorries, wherever business is carried on. Obviously in Ireland, we've got some pretty solid constitutional protections around the inviolability of the dwelling. So let's see how that plays out. I think it's been managed pretty well up to now by regulators, and certainly in this jurisdiction. So I think time will tell on that one. One other question, and our corporate partners often look askance upon us when we use phrases like predation. So we're not allowed to use those type of phrases with our corporate lawyers at times. So I'm asked a question about how do you deal with algorithmic collusion? And the answer to that is with a cold towel, with the assistance of your economists, and not particularly easy. But if there is a will and a demand for a particular seminar, webinar on algorithmic collusion, we'd be more than happy to do that. So without further ado, thank you very much for joining us today. It's appreciated from our side. I hope we've brought something. It's been a bit of a whistle-stop tour. And as I said, if you want to hear a little bit more about any particular topic, do feel free to drop us a line. And with that, we will close out today. So thank you very much for your time, and have a good day.